Hello everyone, my name's Tom Lockridge. I'm here with Aaron Ann Cole, and we're going to be talking to you about Kentucky's strategy for better CDL enforcement compliance.
So let's talk about this concept: one driver, one license, one record. Well, what does that mean? That is a concept that was developed by the Federal Motor Carrier Safety Administration, FMCSA, and it refers specifically to CDL holders, commercial driver's license holders, the drivers that you see on the road behind these giant 80,000-pound semi-trucks and tractor trailers. Because you have to remember, prior to 1986, there was no law, there was no framework in place that dictated the licensing of somebody with a CDL. So before that time, you really didn't have to have any particular training or background in order to drive one of these giant semi-trucks. And importantly, if your license was suspended out west, let's say in Nevada, you could just get another one in another state. You could come to the Midwest and get one in Mississippi, and then come on to Kentucky and grab one here too. There was no accountability. There was nothing keeping these drivers who were breaking the law and threatening our safety on the nation's roadways off of the roadways. So in 1986, there came a grand congressional act, and from that developed this concept of one driver, one license, one record. Now it is the law in every state across the country that if you hold a commercial driver's license, you can only hold one. And that if you speed, if you have a conviction on that license, no matter what state that you're in, it'll go onto this one driver's record that you have. So this concept is very important. It saves lives every day on our nation's highways. And why do we care specifically about commercial driver's license cases? Well, for one thing, CMV, commercial motor vehicle cases are much more likely to be fatal. And think about that. Think about yourself in a passenger vehicle on the highway speeding next to one of these gigantic trucks. It's easy to see who would take the brunt of it. In addition, those crashes are disproportionately high. Even though there aren't as many trucks on the roadways, the collisions are much higher than you would think the average would be. And even the fender benders tend to be deadly. So it's important to look at them and to see the safety consequences that can come from these gigantic commercial motor vehicles. Which is not to say, though, that we are villainizing the drivers of semis. We're not at all. CDL holders are incredibly important to our economy, right? They are the backbone of our supply chain. Each and every one of us need the supplies that come over the highways, but it is so important that these drivers, who have additional training and background and responsibilities, follow the law, because following the law saves lives. And so in 2020, the Commercial Vehicle Safety Alliance, which is known as CVSA, held their Operation Safe Driver Week. And it studied the number of citations that were issued that week. And what it ended up finding is not anything that'll be unusual to anybody on this call. The top citations were speeding, improper lane change, no seatbelt, things of that nature. But when you put a speeding ticket in the context of a semi-truck, suddenly the consequences are much more important, more severe. And I want to tell you about the fatal consequences that can come from these collisions. The photograph before you is the picture of a prosecutor from right here in Kentucky. His name was Doug Wright, and on June 8th of 2009, he was involved in a collision with a defendant called Gabbard, a tractor-trailer driver who was drunk and who ran straight into Doug Wright, killing him. And it's important that you know that even though Gabbard was a truck driver by trade, he was also a Pentecostal minister. And the investigation revealed that he was a Pentecostal minister, which, as many of you all might know, Pentecostal ministers are not allowed to drink alcohol. Well, Mr. Gabbard had a problem with alcohol. He said during his case that he was an alcoholic and admitted during the investigation of this matter that he had drank between 13 and 16 beers out of a 24-pack. Indeed, at the scene, 18 unopened beers were found. Mr. Gabbard admitted that he didn't remember the exact circumstances of this collision and didn't disagree with the eyewitnesses there who said that he didn't even try to pause, didn't even brake before colliding with Doug Wright. And in fact, he didn't argue at all. So he went to trial, ended up being sentenced to 20 years for wanton murder, which is the minimum sentence for that crime. But he did appeal, and at the appeal, the Court of Appeals here in Kentucky were very specific to say that they did indeed find the defendant's conduct to be wanton, that speeding and driving while impaired both led to, particularly in this 80,000-pound vehicle, all led to the conclusion that he acted wantonly when his actions took the life of Doug Wright. I would ask each and every one of you on this call today, particularly prosecutors, if we take out the horrific murder from this scene, but we just focus on a Pentecostal preacher that came up to you in court and said, I made a mistake. I had a couple too much to drink. Could you drop my case? Could you reduce it at least? I'm going to lose my job. I'm going to lose my livelihood. I want you all to think about, would you? Would you reduce this case? And just wonder if next time or the next time, because Mr. Gabbard said during the investigation that this was not the first time that he drove drunk. Maybe it would be the next time or the next that he killed Doug Wright. And so when we talk about these CDL cases, and you're going to learn during this presentation, that a CDL holder's violation, conviction, cannot be reduced, that it's against federal regulation to reduce those charges. It's imperative for each and every one of us to follow the law in these cases so that they don't lead to the death of another Doug Wright.
So if the consequences can be so horrific in these kinds of cases, and in fact, in 2021, there were 806 fatalities on the roadways of Kentucky. 102 of those involved commercial motor vehicles. So about over 12% of the crashes involved commercial motor vehicles, and we're running about that same way in 2022. So how do we figure out who are the people operating these CMVs that are the most at risk? And so the American Transportation Research Institute did a study to try to figure out who are the drivers that are most likely to crash. And they from all of the drivers that were taking part in this study, overall almost 10%, 9.38% of all the drivers in this analysis were convicted of an offense. So what that tells us is over 90% of the drivers drive around all day, every day, without committing any offenses. You know, they follow their training, they follow the law, they operate their vehicles safely, but it's this 10% or a little less than 10% are the ones that are most likely to be involved in a crash. And the study showed that when you have a reckless driving violation, you're 114% more likely to have a crash than your peers. So it increases your likelihood of having a crash by 114% just for a reckless driving violation. For failure to yield the right-of-way, it's 101%. If you had a past crash, then you're 74% more likely than other drivers to have another crash. You know, so these are the people we've got to be on the lookout for, and they're the people that show up on the court dockets around the state. Speeding violation, you're 40% more likely to have a crash than the rest of the drivers if you're someone who is engaged in speeding. And they found that actually younger drivers and really old drivers were the ones most likely to commit violations. But so it's important to know who we have before us and how important it is to make sure that we're following through with the charges that are coming before us, because if we mask their activity and it never shows up on their record, then it will, we'll be missing the people that are most likely to commit future crashes. Kentucky has adopted the federal regulations in 601 KAR 11050. The federal regulations that that established this one driver, one license, one record principle in the federal system. So Kentucky is a part of that process, and it's important that we all understand what that means. Under KRS 281A 110, once a conviction is registered in the court system, we have 10 days to make sure that makes its way into the federal information system that works its way all the way to the licensing authority of the state that issued the license for the driver. So if a driver from Montana commits an offense here in Kentucky, we have 10 days to make sure that the state driver's licensing authority in Montana has a record of that conviction here in Kentucky.
And look, nobody is in a silo, right? This system breaks down if we don't communicate, if we're not all links in a chain that are talking to each other. And so that accurate and timely reporting is absolutely essential. It is Kentucky law, it is the federal law, but it also saves lives. So if you look at the graphic in front of you, the life of a citation, let's call it, starts with law enforcement, right? Doing their job, stopping somebody either in their commercial motor vehicle or, as you're going to learn, just a CDL holder in their personal vehicle, that has consequences to their driver's license as well. So law enforcement starts off, they write that citation, they check the box saying that this is a CDL holder. Well, then that citation moves to the prosecutors, right? They negotiate the citations, they keep in mind the fact that I've got a CDL holder here with that heightened training, and so I have different responsibilities to follow because it's a CDL holder. I'm going to go ahead and move their conviction through exactly as it was charged, make sure that the same thing that the law enforcement officer cited them for is what ultimately shows up on their driving record, so that that record is accurate and complete. And then the citation moves on to the courts, and it's up to the court clerks and personnel to report those convictions to the state driver's license agency, right? The SDLAs then record the conviction, make sure that the conviction that came from the courtroom makes it onto that one license, so that no matter where the driver goes, anybody, a law enforcement officer, a prosecutor in a different state can look down and see the same driving record that we see here in Kentucky. It's also up to the SDLAs to say, oh, okay, they've been convicted of 15 over, okay, they've been convicted of a major disqualification, and go ahead and put that consequence to the license. Let's turn now to what a conviction is in this context, because just like the rest of this presentation, you're going to learn that a conviction has a much broader meaning for somebody that holds a CDL.
Okay, under Kentucky law 281A 010, a conviction is defined as Aaron Ann said, in a much broader sense than you would think. It includes unvacated adjudications of guilt. So if a person comes to court, they're found guilty, that counts as a conviction. But beyond that, if there's a determination that somebody has violated or failed to comply with the law, that counts as a conviction. If there's an unvacated forfeiture of bail or collateral, so let's say a person doesn't show up, they post bail to get out of court, they're supposed to come back on a certain day, they fail to appear, that counts as a conviction for purposes of their commercial driving history. If there's a plea of guilty or a nolo contendere or an Alford plea, which are those last two are ones where you admit you're guilty, but you don't admit you're guilty, but you admit there's enough proof to prove that you're guilty. That still counts as a conviction. If you pay a fine or court costs, or there's a violation of a condition of release without posting bail, that also counts as a conviction. So it's much broader than just the judge finding the person guilty of an offense. It goes way beyond that, and all of those things need to be reported and become a part of the driving history of these commercial driver's license operators.
Now, I'm sure each and every one of you have heard, come on, this is my job, this is my livelihood, don't give me a ticket. You're going to learn later in these presentations that there are certain tickets that they can receive, certain violations, where that's just not true. It may have very little impact on their license. They may be suspended for 60 days or 120 days. But there are certain violations, certain things that CDL holders can be convicted for. that it would endanger the lives of others if they were allowed to continue driving on the roadways. And felony convictions are one of those things, specifically human trafficking. There is a new regulation that has been promulgated by FMCSA and is mandated to take effect in every single state by September of this year, September 2020. And it says that a CDL holder who is convicted of a severe form of human trafficking will then be disqualified for a lifetime for operating a commercial motor vehicle. And this is really, really important. This particular regulation did not exist before, I believe it's 2019, but now it is mandated to be in each and every state. Separately from this, if anybody wants additional training on CDLs and human trafficking, please contact me after this presentation. It's extraordinarily important. There is a new training that we are offering on that I am offering on that. But so you all know, when it does have a criminal implication like that, when it is human trafficking like this or drug trafficking, that can indeed lead to a lifetime disqualification for the driver. And it should, shouldn't it?
Next thing we want to show you is there's a series of videos that were created by the National Traffic Law Center. They were written and produced right here in Kentucky. And it's a 4-part series. They're working now on the creating training around these things. They're building the curriculum right now. But we wanted to show you the first video in the series. This is more of the law enforcement version of the scenario, and they're very cinematically done. So we wanted to highlight that for you here, because this was shot here in Kentucky in cooperation with the Kentucky State Police.
Police officers cannot be reluctant to stop commercial motor vehicles. Officers should treat commercial vehicles like a big car. If you see a traffic violation, stop the commercial motor vehicle and conduct the investigation. Remember, truck drivers are a special class of operator that have extensive training. They understand the consequences to their commercial driving privileges when they violate the rules of the road. Commercial drivers should be held to a higher standard. When a tractor-trailer speeds, the consequences can be deadly, so it's important to stop them when you observe the violation. Don't forget, the size and destructive power of an 80,000-pound tractor-trailer when traveling at 12 miles per hour is the same kinetic energy as a 3,200-pound passenger car traveling at 60 miles per hour. Trucks traveling at 65 miles per hour will take up to 2 football fields to stop, and the distance only increases in rain, snow, or ice. Be aware that they will need to find a safe place to stop on level ground. If you notice any spills, leaks, or unusual odors coming from the vehicle, it may be wise to call a certified CMV inspector to have a close look at the vehicle. Pay attention to any signage indicating hazardous materials on board. As you approach the vehicle, keep an eye on the suspect's mirrors to observe what's happening inside the cab. Approach the vehicle from the passenger side to provide protection for the passing traffic.
Sir, Trooper Dameron with the State Police. When I pulled you over, as you were doing 71 and 55.
Me? I was speeding?
Yes, sir. Need to see your operator's license, proof of insurance, and registration.
Yes, sir. I'm running just a little behind. I'll slow it down.
Okay, where are you coming from?
Denver.
Denver. When did you leave Denver, sir?
I had a drop over there and I loaded, and now I'm headed back to Nicholasville. I got a drop there this morning.
Okay. I've noticed your eyes are kind of bloodshot and red, and there's a pill bottle here. You don't need any type of prescription medication?
Well, that's just my prescription that my doctor wrote me. I take Ritalin.
Okay. Well, I need you to step out of the vehicle and meet me at the front of your truck. When you step out, be sure to watch for traffic and be safe.
Unless you are MCSAP certified and conducting a full inspection, other documents should not be required. The FMCSA has established a 0.04% as the blood alcohol concentration level at or above which a CDL commercial motor vehicle operator is deemed to be driving under the influence of alcohol and subject to the disqualification sanctions in the federal regulations. A CDL driver of a commercial motor vehicle will be pulled from service with any level of alcohol in their system, or if they've used alcohol within 4 hours prior to driving a CMV. If you are not trained to conduct impaired driving investigations, call an officer with that training. If you are trained in an impaired driving investigation, treat the investigation just like the driver of a big car.
Okay, sir. Now what I need you to do, I need you to just have a seat in your truck and wait, and I'll be right back with you in a moment with your citation.
Is there any way I can get a warning? I could lose my job. Got kids.
The officer should not let potential driver sympathy influence the decision to issue citations. Issuing the appropriate citation is the first critical step to ensuring driver accountability. Not issuing a citation, or issuing a citation for a lesser charge, permits the driver to avoid a conviction that would otherwise be posted on their driving record. By not issuing the citation, the next time a driver gets pulled over for a violation, it will appear that this is the first time the driver has committed that violation and created that danger on the highway. This allows a driver to avoid the consequences and potentially continue to drive dangerously on the roads. In commercial motor vehicle cases, officers should issue the citation for all violations whenever probable cause exists for the offenses. Officers should run the driving history on the driver and verify the registration of the owner. Confirm that the CDL or commercial learner's permit is current and issued to this particular driver. On every citation written to this driver, be certain to check the boxes indicating this is a CDL holder and record the state of issuance of the CDL. Be sure to indicate the type of motor vehicle on every citation. If a commercial motor vehicle is being driven by a non-CDL holder, the officer should list the type of vehicle being operated on every citation issued.
During this presentation, Tom and I have referenced masking. And I know in this day and age, when you think about masks or you think about masking, you think about what, right? That cloth, that thing that goes over your mouth. Well, that is not what we're talking about here. We're looking at a more literal definition of masking: to hide, conceal, to keep from the true nature of a violation from showing up on the driving record of a CDL holder. And so the regulations say that there is absolutely no masking, not in Kentucky and not anywhere else in the United States. And so what is masking? Masking is against the federal law. It's also against Kentucky law. And masking is a disposition that prevents the violation or a conviction of a CDL holder from being reported on their driving record. The Black's Law Dictionary defines it as the practice or an instance of a defendant's agreeing by plea bargain to plead guilty to a less serious offense than the one that's been originally charged, pleading guilty to parking on a curb when you've been charged with speeding. It is the idea of hiding, of masking, of concealing the true nature of a violation and preventing the true nature of that violation from going on a CDL holder's driving record.
Kentucky has once again adopted the federal approach to this in 281A.185. It says flat out, the Commonwealth shall not mask, defer imposition of judgment. So we can't defer the judgment for some time and let them continue to drive while the case is pending, or allow an individual to enter into a diversion program. That's not allowed under the masking provision here. That would prevent a CDL holder's conviction, anything that would prevent their conviction for any violation in any type of motor vehicle. So it doesn't have to be their commercial motor vehicle. It has to be, it's masking if they hold a CDL and they commit an offense in their personal car. That still counts. It counts as masking if we do not have that violation show up on their record. Of a state or local traffic law, from appearing on the SIDless driver record. That's their commercial driver's license information system driver record. Whether the driver was convicted for an offense committed in the Commonwealth or another state. So we've got to assure we'll violate this masking provision unless, if we defer prosecution or we put them in diversion or we do anything that keeps that masks the true act the true violation that they committed from showing up on their driving record. So amendment of charges can be a real problem when it's looked at under the lens of masking. Now, there are a couple of exceptions. Parking violations do not show up, vehicle weight violations do not show up, and vehicle defect does not show up or is not affected by the masking provisions.
Now, often when I train on this particular topic, prosecutors will come up to me and say, "It's my courtroom. Who are you to come into my courtroom and tell me what kind of negotiations I can do, what kind of dispositions that I can make?" And I typically say, I am not telling you anything at all. The federal regulations are the law that sets forth what constitutes masking and what doesn't. But it's really important to remember that, of course, judges and prosecutors maintain the authority and the discretion to negotiate dispositions and dismiss charges, even if a CDL holder is involved, if those charges are unsupported by evidence, if they're constitutionally infirm, or they're procedurally improper. So if you have a case that's going to trial with the CDL holder, but you're missing your primary witness, obviously you cannot sustain your burden. You have the authority and discretion there to do what needs to be done in the interest of justice, and that will not be considered masking. Similarly, if there is some reason that you cannot, sustain your burden in the case, you maintain that authority and discretion to do what needs to be done. But for those reasons, you cannot mask when it comes to dispositions involving commercial motor vehicle drivers. And so, as Tom talked about earlier, deferral and diversion programs are both things that would constitute masking in this context, because they allow a CDL holder or a CLP, a commercial learning permit holder, to perform actions that result in that conviction being downgraded and erased. And if the conviction is downgraded or erased, it's what? It's being masked. The true nature of it is being concealed. And so the regulations do not allow deferral or diversion in CDL cases. Similarly, those pretrial programs prior to preliminary judgment that would allow a CDL holder to complete a program that results in the charge being downgraded, dismissed, or would prevent the entry of that preliminary judgment. All of those things, that downgrading, that dismissal, that prevention, they all are what? They're all masking the true nature of the offense. And similarly, are not allowed under the federal regulation. And so examples of that are community service, traffic school, DUI or drug court, and so on. All of those things are prohibited by federal and by Kentucky law, which has adopted the federal law. And so finally, we come to the third video in this series. There was a second, and I encourage each and every one of you to go to the NTLC website and look at these videos. They do a wonderful job of starting from the very beginning to the very end of this life cycle of the citation. First one is law enforcement, as we saw in a commercial motor vehicle. The second one we didn't watch is what happens if you pull over a CDL holder in a personal vehicle. But this one is the courtroom itself. When a prosecutor is faced with cases involving CDL holders, what is the correct thing to do in order to uphold Kentucky and uphold federal law? This is video 3 in the 4-part series From Roadside to Record.
Prosecutors handling cases involving a driver with a commercial driver's license should remember, truck drivers are a special class of operator that have extensive training. They understand the consequences to their commercial driving privileges when they violate the rules of the road. Holding a CDL is a privilege, not a right, and is subject to strict control by the state licensing agency and federal safety regulations. When handling a case involving a CDL holder, a prosecutor should remember, a CDL holder is a professional and should be held to a higher standard. When reviewing a traffic citation involving a CDL or CLP holder driving a CMV or a non-CMV, make sure the appropriate boxes are checked for CDL, CLP, and type of vehicle being operated for each individual citation. Notify the court and the clerk if a citation is not properly marked so that the court file will be correct. Always run the driving history on the subject. If the driver is from out of state, the prosecutor should make every attempt to obtain that state's driving history, including requesting it from the defense attorney.
You can't be serious. You're going after his CDL.
Your client shouldn't have used his car to commit a burglary if he wanted to hang on to his CDL.
It's not like he ran over somebody. His driving had nothing to do with his crime.
Well, no, except for the fact that he used his car to get rid of $20,000 worth of merchandise.
Come on. He didn't know that he would lose his livelihood over that. I mean, they don't do that in Washington County.
He should have known that from studying his state CDL manual. He should have known better. And they ought to be doing that in Washington County.
Prosecutors must not give the driver a break on the charges, as it may constitute masking, and masking permits the driver to avoid a conviction that would otherwise be placed on their driving record. By not prosecuting the citation as charged, the next time a driver gets pulled over for a violation, it will appear that this is the first time the driver has committed that violation and created that danger on the highway. This allows a driver to avoid the consequences of their actions and potentially continue to drive dangerously on the roads.
That masking business only applies if he was driving a commercial motor vehicle.
No, masking applies to these professional drivers even if the violation occurs in their personal vehicle. I'm sorry, you're wrong about that. The offer is he completed the felony as it's charged, which should result in the disqualification of his commercial driver's license.
Only the state driver's license agency can say with certainty what and when a disqualification will occur.
Hi, Ann. Hope you're in a good mood today. I wanted to talk to you about my guy with the speeding ticket. We need to make it a non-moving violation. How about defective equipment?
Your client was driving 71 and a 55 in his commercial vehicle. What do you want?
Come on, he has a family. Have a heart.
You've got kids.
I can't.
Federal regulations prohibit the state from resolving a CDL violation so as to mask, reduce, or dismiss a CDL holder's traffic infractions, such as speeding, following too closely, DUI, etc.
Do you really want my guy to lose his job over a speeding ticket?
Your client is the one that was speeding, and on top of that, he was speeding in an 80,000-pound commercial motor vehicle. Everyone knows that CMVs cause a lot more damage than those smaller vehicles, especially traveling that fast.
The size and destructive power of an 80,000-pound tractor-trailer when traveling at 12 miles per hour is the same kinetic energy as a 3,200-pound passenger car traveling at 60 miles per hour. Reducing the mobility of certain offenders by holding them accountable may go a long way toward impeding their ability to commit new offenses.
How about diversion or deferred prosecution? If he's good for 6 months, we just make this all go away. If not, then he'll plead and you can ruin his life.
Look, my hands are tied. Our state has adopted the federal regulations.
Fine. At least he's got a CDL in Kansas, too.
What?
Never mind.
A CDL driver can only have one CDL. Federal law prohibits drivers from holding a CDL in more than one state.
71 and a 55. That is what the LiDAR showed as the defendant was barreling down US 60 in his 80,000-pound fully loaded commercial motor vehicle. These commercial motor vehicle drivers know that state and federal regulations hold them to a higher standard. These states entrust these drivers with the privilege of owning a CDL and of operating vehicles with 20 times the mass of an average car. And in exchange, these drivers agree to keep the rest of us safe. They receive special training in operating these vehicles safely. They agree to strictly follow the traffic laws. They have to know the disqualifying events that could cost them their CDL, and they have to report these potential disqualifying events to authorities in their home states in order to ensure that their driving records are complete and accurate. In this case, the defendant committed serious violations of the traffic law when he operated his massive CMV at over 15 miles per hour above the speed limit, endangering not only himself, but everybody else on the roadway. For those reasons, we would ask for a guilty verdict.
Be sure to place on the record that the defendant was found guilty of specific charges. Ensure conviction documents reflect that the defendant was a CDL or CLP holder and specify the type of motor vehicle being operated. When charging a felony that could lead to the disqualification of the defendant's CDL, be sure that the charging instrument contains allegations of the defendant's license status, including his license number and the elements that justify the disqualification. Upon conviction, when reviewing a driver's status, review the criminal history to check for potentially disqualifying non-traffic-related felony convictions. The prosecutor should be aware of the CDL implications of certain criminal convictions that may disqualify a defendant from CMV operation. A CDL holder convicted of any felony committed in any type of motor vehicle will be disqualified from operating a CMV for a minimum of 1 year to life. It should also be entered on the record that the convicted offense violates the FMCSA regulations and/or state laws. The prosecutor should ensure that the court file properly reflects the judgment of conviction and the relevant driver's license information. The prosecutor should be aware that the court clerk is responsible for sending the conviction to the SDLA within 10 days of conviction for license ramifications to be imposed on the defendant's driving privileges.
Okay, so why are we worried about all of this, other than the loss of life potential? There's federal funding at stake. States are required to comply with the federal regulations. Kentucky has adopted those. We have law statutes in place that would assure our performance. But for states who do not comply, if we have too much masking going on in our state, the FMCSA can deduct 4% of the federal highway funds for the first year of violation, and for the second year or more, it's 8% of the state federal highway funds that would come into the state. So there's millions of dollars at stake, and we don't want to be. You don't want to be the county attorney in the county, or the district judge in the county, or the assistant county attorney that is responsible for a finding of masking that's been repeatedly going on in our state that leads to the reduction of 4% of the federal highway funds. Yeah, this is the video that is the fourth video in the series. It's what happens, what's the clerk responsibility once those convictions are recorded or reported in the court system. What is the clerk supposed to do with those with that information?
Hey, Susan, do you need help with anything else? I know we have 3 CDLs to report.
3?
Yes. We have Henderson for using his vehicle in commission of a felony, Sample for speeding 16 miles per hour over, and Parker for failure to appear.
I'm not sure I understand.
It's a disqualifying event for a CDL holder to use a vehicle in commission of a felony. Today, we put everything on the record, all of the identifying details. The defendant's name, his date of birth, his CDL license number, and the state that issued his CDL. And the court made a specific finding of fact that the defendant had used his car to commit that burglary. You should have everything you need to report on that one.
I have all the identifiers and the right code. We should be good to go. And I know I need to report on Sample 16 over. You should be easy. I have all the identifiers and the right code.
That's great.
But the failure to appear on Mr. Parker, I'll keep an eye on that one until the court finds him guilty.
So, a conviction under these circumstances has a much broader meaning than just a simple finding of guilty. Today, the defendant failed to appear, which was a condition of his release, and the court forfeited his bail when he failed to appear. Under federal regulations, which this state has adopted, a conviction includes an unvacated forfeiture of bail, as well as a violation of condition of release. For CDL purposes, the defendant has already been convicted, and that conviction needs to go on his record.
Okay, I have all the identifying information. I'll get the right code and get the record submitted.
Thank you.
Federal regulations require states to report convictions for commercial driver's license and commercial learner's permit holders, and for commercial motor vehicle drivers who should have had a CDL within 10 days to the SDLA of the state that issued the license or permit. SIDLIS is a nationwide computer system that enables driver's license agencies to report important information related to a CDL or CLP holder's record so that the information can be relayed to the state that issued the CDL. Police, prosecutors, and the courts are all important links in the chain that must perform their jobs completely in order to ensure the prompt and accurate reporting of CDL violations. Prosecutors, judges, and clerks must all be aware that some crimes, like drug trafficking, human trafficking, and the commission of any felony involving any type of motor vehicle, carry mandatory disqualification for CDL holders according to federal law. The first stop for the information entered by the clerk is the state driver's license agency. If all the identifiers given to the court and reported by the clerk are accurate, including the name, license number, and state of issue, and the date of birth of the driver, the system will match the information to the correct driving record and send the information up the chain to SIDLIS. The Commercial Driver's License Information System, SIDLIS, is a nationwide computer system that enables state driver's licensing agencies, SDLAs, to ensure that each commercial driver has only one driver's license and one complete driver record. State driver licensing agencies use SIDLIS to complete various procedures, including transmitting out-of-state convictions and withdrawals, transferring the driver record when a commercial driver's license holder moves to another state, and responding to authorized requests for driver status and history. The one driver, one license, one record system makes it much easier to accurately track the driving history of any driver of commercial motor vehicles. The last stop for the information is the state of issuance, the state that issued the commercial driver's license or commercial learner's permit to the offender. SIDLIS will load information from an out-of-state conviction to the record of the driver in the issuing state electronically. The state driver's license agency of the state of issuance will have everything it needs to impose the appropriate commercial driver's license sanctions. It is vitally important that police officers capture all identifying information completely and accurately. It is equally important for the clerk to enter the information into the system with absolute 100% accuracy. If even one identifier is incorrect, missing, or inaccurately recorded, the record may not match a driving history in the nationwide system. When this happens, the system will generate a rejection report that is sent back to the county clerk. The clerk must react quickly to the rejection report by providing complete, full, accurate identifying information and issuing a correction that can be resubmitted to the state driver's license agency within the 10-day limit. If the information in the rejection reports are not modified and corrected, they could remain in the rejection filing system and never make it to the record of the offending CDL holder. Court clerks and the SDLAs should work together with their technical staff to ensure that when errors occur, that both the clerks and the SDLAs are correctly processing the errors. The correction will go back to the automated system, and if it matches a record, will be entered into the records of the CDL or CLP holder. The one driver, one license, one record system only works if every link in the chain has performed their job fully. From roadside to record, everyone must do their part to create a complete and accurate driving history for drivers operating commercial motor vehicles on our highways.
So how are we doing with our enforcement in Kentucky, the beautiful bluegrass state? In April of 2020, they issued a report. It's called the Commercial Driver's License Prosecution, Adjudication, and Data Transmission Report. It was done by the Kentucky Transportation Center in cooperation with the College of Engineering at the University of Kentucky and the Kentucky Transportation Cabinet. They studied 15 years, from 2002 to 2016, to see how we were doing. So there was 103,000 citations total. Over 79,000, or about 76% of the charges, were speeding charges. There were failure to obey a traffic device were another 8,000. So about 84% were either speeding or failure to obey charges. And most of the action, as you might expect, occurred along our interstate highways. The darker the color in this particular diagram, which you see, along the I-75 corridor, along the I-65 corridor, out there in I-24 and I-69, up around in the triangle between Cincinnati, Lexington, and Louisville. That's where most of the action was taking place, or most of the violations were occurring. So in this 15-year study, they were able to break down the conviction rate, dismissal rate, amendment rate, diversion rate for each county in the study. They broke it down first, though, by Kentucky State Police region. Region 2 had the most action. That's the I-65 corridor between Louisville and Bowling Green, and all the way to heading towards Nashville. The Region 3, which was the triangle between Louisville, Lexington, and Cincinnati, that's had the next highest. Out west with 24 and 69 was the next one. And then it had less volume in southern and eastern Kentucky. But when we analyzed how we were doing, Region 1, which is the far west, had a 61% conviction rate. Dismissal rate was 18%. Amendment rate almost 14%. The real areas of concern, though, Region 4, which is south central Kentucky, had a 42% conviction rate, 41% dismissal rate, 13% amendment rate, and then with the lowest volume, but the lowest conviction rate is Region 6, which is kind of southeastern Kentucky, only a 27% conviction rate, 41% dismissal rate, 17% amendment rate, and they had an 11% diversion rate, which is strictly prohibited under the statutes that we've talked about. They can't be giving diversion. The study has indicated that we've got some work to do here in Kentucky, and so it's important to come up with a game plan for how we're going to remedy this. So Erin Ann, tell us about the plan.
Well, here in Kentucky, Kentucky is actually the cutting edge state on this issue more than any other state across the country. Kentucky has developed the CDL Advisory Committee, it's called. It is chaired by our state CDL coordinator. Her name is Judy Wolf, and it's in conjunction with the Kentucky Transportation Center. And so several years ago, they sought and they received a commercial driver's license program implementation grant, a CDL PI, and that is from the FMCSA that we've referenced throughout this presentation. And with that, they have established two different things: the overall CDL Advisory Committee and a judicial project to go with that. And so the objectives of this committee are, one, to assemble a team of stakeholders. We have talked a lot today about being good links in the chain, creating this bridge of communication. That's what's happened here. Law enforcement is on this, traffic safety professionals, prosecutors, the new TSRPs, people from the trucking industry. Anybody with an interest in this can be part of this committee. Regular stakeholder meetings are held to talk about emerging issues in the community and long-term challenges for CDL compliance. And then there's an outreach part of it too that helps with training and education to the traffic safety stakeholders across Kentucky. And so part of the grant that this committee also looks at is getting good quality data and performance measures that can be relied on. And then in addition, this year, a strategic planning session was held. And so there was a Between the Lines article that you can go to NTLC's website and read. It goes through the history and the background and the groundbreaking work that this committee is doing. And as part of that article, we talked about the fact again that there are these issues that are coming on, masking, of course, but how to make sure that that communication happens in Kentucky, where we are seeing some places with these high diversion rates, something that is strictly prohibited by the statute. And so this committee helps all of us talk and create this recurrent contact between stakeholders that doesn't just happen one time, but happens quarterly and strengthens those bonds, those links between each of the aspects of the chain. That communication is growing and growing as a result of the committee. And so as we've talked about, we wanted someone from every link on the chain, the licensing process, to the driver and vehicle, to roadside, to the court, to getting it on the record, talking throughout the program and creating a true collaboration. And that's what we've done. And so again, those traffic safety stakeholders from the Kentucky State Police, from the cabinet, the TSRPs are on here, the Judicial Outreach Liaison, Judge Holbrook, and then requests for representatives from FMCSA, the Kentucky Trucking Association, and other partners that allow us to have this living, breathing, and ongoing conversation.
Erin Ann mentioned the CDL outreach project, judicial outreach project, and so primary goal of that is just to make sure that people receive the education that they need to put this issue at the forefront so that we can begin to see improvement in the statistics that are being generated in the courtrooms all across the state. Right. The next thing, in addition to the outreach project, is the pilot project. They got additional funds for a grant to have a pilot project in 2 court systems that will develop a standardized protocol that will be designed to generate better results in the courtroom. And we'll work with those 2 counties to work the bugs out of this particular standardized protocol to make sure that it's working as expected. And then that plan, once proven, will be rolled out to the rest of the state as a standardized protocol that the whole state can begin to utilize. So what we've, as Erin Ann said, the advisory committee and the outreach project are all designed to create bridges where there have been silos, people working on their own. And so the idea is to get everyone working towards the same goal, generating the same level of enthusiasm and the same quality of information that everybody has to understand what their role is in making sure that Kentucky is remaining in compliance. And it's an easily repeatable model that's going to hopefully be rolled out across the state. We know that FMCSA, there's membership on the advisory committee. They're interested in what we're doing, and assuming we can continue to show improvement, it may be a model that for the nation.
Absolutely. And so there are a lot of resources that have been developed in order to help other traffic safety partners that are interested in this and want to learn more about CDL holders, licensing, and the like. If you scan this QR code, it'll lead you to resources from the National Traffic Law Center, including the newsletters, Between the Lines, the monographs, and things of that nature. There's a quick reference guide on masking, a CDL quick reference guide as well, and a really handy bench card that will go through with those tables we talked about for disqualification, and just give you a right there on your table view of how to prevent masking and how indeed to follow the law when it comes to CDL holders. You can also use the QR code at the top if you'd like a direct link to the videos that you watched today. Those can be used in your own training. I'm also happy to come train with you on any of these pieces of the citation process. There is a conference coming up June 14th through the 16th. It is free. It is virtual. You can register for it using this QR code. It will also have speakers from across the spectrum on the very basics of what is a CDL. It'll have a component on human trafficking. There will be a speaker at Truckers Against Trafficking that will be there. FMCSA sponsored this, and there will be a great many speakers for anybody interested in attending. It's in the afternoon these 3 days, around 1 to 5 every day, but I promise it'll be a great use of your time to learn more about the CDL world. This is our information at the National Traffic Law Center. I'm Erin Ann Cole-Funson at the very bottom there. If you have any questions at all, if we can answer anything for you regarding masking, disqualification, licensing issues, please do email me without hesitation. If you would like more training on masking, or if you're interested in the CDL human trafficking training that we put together, we will come to you and do that as well. It has truly been an honor to speak to you today. And I've got one more thing to say as well. Here's a QR code, those questions that I told you about. If you have a technical assistance question too about masking CDLs, anything that you would like me to help with, or my senior attorney, Jim Camp, we will do that too. You can email me, or you can use this handy dandy QR code. Now, it has been an honor today. Thank you so much for having us.
Yeah, and this is my contact information if anybody needs to reach out to me at the offices of the Attorney General. I can certainly get a hold of the new TSRP and make sure that we respond quickly to whatever information that you need. So thanks again for having us. We hope you've enjoyed learning a little bit more about the commercial driver's license enforcement in Kentucky.
Thank you so much.